Hello, and thank you for joining us today. My name is Yongki Hong, and I am a senior associate at Scott Legal PC. Today, we are going to spend some time talking about E-2 visa options for low investment amounts and high-risk E-2 visa cases. And we are very lucky to have our firm's founder and managing partner, Ian Scott, as the speaker for this webinar. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm, and we offer services in a wide range of areas, including E2, O1, L1, TN, H1B, any types of employment-based green card cases, as well as family-based green card cases also. That said, we are especially well known for our work with the E2 visas, and we have a very strong reputation in this area. We have processed hundreds of E2 visas, and many of them higher risk cases, and have worked with the US consular offices all over the world. And one reason for this focus is that our firm was founded on an E2 visa by Ian Scott himself. He knows the E2 visa world inside and out. I'm sure you will pick up a lot of valuable information from him today. And at the end of the webinar, we'll send you several useful tools, a copy of a PowerPoint presentation we'll go over through today, and a link where you can download guides with more details on visa options, and a link to sign up for additional webinars, and a link to webinar recording on YouTube. We encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And also a link where you can set up a consultation for any other questions. Finally, for any questions during the webinar, please type them into the chat box or Q&A box. We'll address all the questions at the end of the presentation. And with that, I will hand it over to Ian to get us started.
Great. Thank you very much, Yongki, for the introduction. And it's great to be here. And as Yongki mentioned, the E-2 visa is near and dear to certainly my heart, given that the firm was founded on an E-2 visa 13 years ago. And we certainly are an E-2 visa success story because E-2 visas are all about creating U.S. jobs. And we certainly have done that. So without further ado, we're going to jump right into the presentation and we'll just move to the first slide. And we are going to talk about the E-2 visa requirements. And I think that first and foremost, the E-2 visa is going to be available to people from certain countries. There are around 80 or so treaty countries, and they're countries that have signed treaties with the United States. And there, as I said, there are 80 of them, and they're in many, many places. There are E-2 treaty countries in Africa, Europe, South America, the Middle East, and certainly, of course, North America. And but that is the key, that you are a national of the treaty country. And what that means is that you have a passport. So your country of birth doesn't matter. What matters is that you have a passport from that country. So the other thing to keep in mind here is that the E-2 visa treaty countries change. So sometimes they're added. So very recently, Portugal was added to the list, and very recently, New Zealand was added to the list. But sometimes they also drop off. Ecuador was on the list, but is not anymore. So sometimes there are changes that are made with respect to the E-2 visas, and really that just has to do with whether treaty has been signed. So it could be a new treaty that's been signed, or that the two countries no longer want to continue with the treaty that existed before. So then another key element of the E-2 visa, and this is if you're doing an E-2 investor visa, is that there's always going to be a company in the United States, and that company has to be at least 50% owned by nationals of the treaty country. Now, if you are the E-2 visa investor, then it's going to the company is actually going to be at least 50% owned by you. But in terms of to qualify for an E-2 visa, any E-2 visa, so whether it's an E-2 employee visa or an E-2 investor visa, the E-2 company does have to be at least 50% owned by nationals of the treaty country. And again, that is someone who has a passport from that country. So you could a particular entity could actually be owned by two nationals from different treaty countries. So let's say, for example, someone was a UK national and someone was a Canadian national, and they each own 50% of an E-2 visa company. Then both parties would be able to get the E-2 visa, and the particular company would have the nationality of Canada and the United Kingdom in that particular example. And the reason that nationality is important is because when there is an E-2 visa investor from a particular country, that investor can bring E-2 employees from that same country. So in the example that I just used, the two investors would be able to bring employees from either the UK or Canada. So that's something that is quite beneficial, and one of the reasons that some multinationals really like E-2 visas, because we can have an investor, and then later on you can have the investor can bring nationals from that country under the E-2 employee visa. The other big aspect of the E-2 visa is that it requires an investment, right? So this is an investor visa, so there's kind of no getting around investing. And unlike some other investor visas where there's a specific dollar amount that has to be invested, the E-2 visa does not have a specific dollar amount. And we're going to talk about that a little bit more as we move through the slides. But the one thing to keep in mind here is that the money that is invested has to be at risk. And really what at risk means is the money is spent, right? So you can't just put money in a business bank account and say that I have this great business idea and I want to apply for an E-2 visa. The government really is going to be looking to see that you actually have spent the money. So, you spent it on lease, equipment, maybe employees, or whatever is required to get the business up and running. The other aspect with respect to the investment is you do have to show the government where you got the money from. So there's a requirement, it's called the source of funds requirement. And that is something where you do have to, so if the money came from savings, you would have to show tax returns and accumulation of funds over time. If it came from sale of a home, you'd have to show documents related to that. And as I said, we're going to talk about the how much is required when we move to some of the next slides. And there on the slide, we just list some typical E-2 visa expenditures, some of which I have already mentioned. So the other requirements with respect to E-2 visas. So the investment is a significant requirement. Being a national of the treaty country, significant requirement. And the next significant requirement really has to do with hiring US workers. And to some extent, that's really what this visa is about. It's the reason that the United States has decided that they want this visa, or they like this visa, is because the visa does create US jobs. Because in essence, there is a foreign national who's coming, they're starting a company or buying a company in the United States, and they're creating employment in the United States. So that is required for the E-2 visa. So if someone, for example, wanted to come to the United States and offer a service and they just wanted to be a solo practitioner, then an E-2 visa would not be the visa for them. They would be required to ultimately hire US workers. You don't have to have US workers when you start the company or when you apply for the E-2 visa, but ultimately you would have to have US workers. So that is something that you take into consideration if you were interested in an E-2 visa. The other aspect of an E-2 visa or requirement is the business has to be real and operating. And really what that means is that the business should be at the point of operational it can be operational, or at the point of operational when you apply for the E-2 visa. So this isn't we get this question a lot where, people say, well, can't I put money in a business bank account and I have a business plan and I have an idea and apply for the E-2 visa? Well, that's not really, that won't work at all. You not only have to spend the money, but also have the business to the point of operational. So, lease signed, bank account set up, maybe if you're opening up a restaurant or something like that, the space would already have to be organized, and really the door is just ready to open. We had an applicant who went to a consulate some time ago. She was opening up a gym, and the consular officer asked her, if I went to the gym right now, what would I see? And the applicant said that we've leased the space, we have the equipment, everything's ready to go. They're just waiting for me to get the visa to open the doors. And that's really what an officer is expecting to hear in terms of how far along or the business being at the point of being operational. The individual has to be coming to the United States to develop and direct the business. So usually this is established when we indicate that the person owns at least 50% of the business. But we also do look here to the person's experience. And one of the things that is interesting here is that the E-2 visa is not a visa that is available for people who just want to invest and be a passive investor. So even if it was an active business, let's say someone, for example, purchased a restaurant and it was active business, but they didn't really want to participate in the business, and they just wanted to collect profits from the business, then that would not make a good E-2 visa, because the E-2 visa does require that the person is coming to the United States to develop and direct the enterprise. The individual has to have the intent to return home to their home country. This can usually just be established by a letter, a note that they sign that says that if they didn't have the E-2 visa, they could return. But the E-2 visa doesn't have a timestamp. You can renew the E-2 visa indefinitely. I've had it for 13 years, and certainly it's a visa that you can keep for life. They don't expect you to come and start a business and develop a business, and then after 10, 15, 20 years to just leave it. You can continue to renew an E-2 visa as long as you continue to hire US workers and your business remains viable. And then the E-2 visa, a lot of people start E-2 visas businesses, and then a lot of people purchase an E-2 visa business. So you could, let's use the example of a restaurant again. You could start your own restaurant. You could lease the space and get it refurbished, buy all the equipment, buy the cooking material, food, etc. You could start your own business, develop a business plan. Or you could buy a business. So if there's an existing business that has employees and is viable, you could buy a business. And then one last thing, when you are buying a business, this is the time when it is possible to enter into an arrangement, which is an escrow arrangement. So this is an arrangement where you're purchasing a business, and then instead of giving the money to the seller, you give the money to an escrow agent, and there's an agreement between the escrow agent, the seller, and yourself that basically says that if the E-2 visa is approved, the money goes to the seller, and if the E-2 visa is denied, it goes back to you. And the only condition in that escrow agreement or the only condition that's permitted is that it is conditional on the approval of the E-2 visa. So the government does find that acceptable. That's in the regulations. It's quite specific. They do find that acceptable for the funds still being at risk, because the agreement says that if the visa is approved, the money does in fact go to the seller, and there's no way for you to get that money back based on the agreement. So the other interesting thing with E-2 visa that, question that often comes up is, how long is an E-2 visa valid for? And this is an interesting question, because the answer is it depends, and it really depends on a few things. So one, it depends which country you're from. So as I said, there are around 80 or so E-2 visa countries. So, Canada is on the list, United Kingdom is on the list. Egypt is on the list, Morocco is on the list. So let's contrast those four countries that I just mentioned. An E-2 visa for the UK and Canada can be issued for up to 5 years. The E-2 visa for Morocco and Egypt, it's much less time. It's 3 months. So when the visa is issued for 3 months, it means that the individual can enter the United States within it. Like, think of a visa as just an entry document only. So what that means is the person can enter the United States with the visa, and then when they enter the United States on an E-2 visa, anyone who enters the United States, regardless of the expiration date on your visa, you're given 2 years in E-2 status, which allows you to live and work in the United States on E-2 status. But if someone had a 3-month visa and they were in the United States for the 2 years, and then let's say a year and a half in, they had to go back to their home country, or they had to travel anywhere outside the United States, they would need a new visa to re-enter. So the countries that have a short visa validity period, and there are a few of them, those particular countries, the E-2 visa can be a challenge. It can be a challenge because of the fact that if you do leave the country, then you do have to obtain a new visa before re-entering. So that means going back to the consulate and getting another visa interview, et cetera. There's nothing to suggest you wouldn't get it as long as the business was still operating, but it does create an inconvenience, at least at a minimum, an inconvenience. The other factor that influences how long an E-2 visa can be issued for is that an officer may, for example, let's say Germany is another E-2 visa country, and this can be issued for up to 5 years. But an officer, when they go to the consulate, they may feel that the individual, the business isn't that strong, or they're not sure if the person is going to be able to hire a US worker. So instead of issuing it for the full 5 years, they might issue it for 2 or 3 years. And then they say that come back in 2 or 3 years and show me that you actually were able to hire US workers. And after you've done that, then and only then will we allow you to renew the visa. And then maybe if they do show that, then maybe when they do renew the visa, they'll renew it for the full 5 years. And we talked about the I-94. When you enter the United States on a visa, you do always have to check your I-94, because I-94 is what governs your stay in the United States. And when I said that the person who enters even on a 3-month visa into the United States and they're given 2 years in E-2 status, that 2 years is marked by the I-94. So you'd go on a system and you'd see that the individual was given 2 years. And you do have to check, because if you go on the system and it's incorrect, like let's say they admitted you on a B for 6 months or something like that, then it's problematic, because that's what governs your stay, and you do have to get it corrected. If there is an error, then you do have to actually get it corrected, because that is what dictates your lawful status in the United States. Perfect. So now I did promise that we come back to how much investment is required for an E-2 visa. So the interesting thing with an E-2 visa is that the government doesn't give or indicate a particular amount that is required to be invested. Instead, they say that the investment should be substantial. And what that means, it means a few things. So one is that the government expects, if your investment is, say, under $400,000, the government expects you to spend everything that's required to get the business up and running, right? So, and they use what's called the proportionality test, and basically they say that let's say that it costs $400,000 to get a business up and running, they'd expect you to spend all of it. Let's say that the business only costs $75,000 to get up and running, they'd expect you to spend all of it before applying. Well, let's say the business cost $1 million to get up and running. Then they might be satisfied if you just have spent half of it, 500,000. And there's no kind of specific rule with respect to this, but immigration lawyers will look and indicate whether or not they feel that you actually have spent enough to be able to apply. Now, for cases like consulting businesses or even a law firm, most of us know that you could set up a law firm or set up a consulting business with just a laptop, and really requires very little in terms of what you actually have to spend. But unfortunately, the government, regardless of whether that is common knowledge or not, the government does require that you spend, and unfortunately, sometimes clients will have to spend money on things that they maybe otherwise wouldn't have spent money on. For example, when I started my law firm, I took out a 1-year irrevocable lease, and it was $1,700 a month, and I didn't need it. I didn't have any clients, and I didn't need the lease at all. But it certainly did help with respect to bolstering my investment amount. So sometimes I think that's needed to get your investment amount up. And we don't recommend these days to spend less than $50,000 to get an E-2 visa, and even $50,000 we feel is a low amount. But I think that the other kind of thing to think about, though, is, and a lot of clients, they're quite insistent on trying to find out exactly what that number is, and we try and discourage that, because we say that the number is important. But I think other things can be important as well. So, for example, it depends on the type of business that you are running. So, for example, we had someone recently that opened up a doctor's office, and she ended up spending probably $25,000 to $30,000. But it was crystal clear from her business plan and the insurance contracts and things that she had that she was going to be able to hire US workers quickly, and the business was going to thrive. So I think that depending on the type of business, it could be that the government is willing to accept less, because the investment amount is really a proxy for hiring employees. They say, okay, well, if the person makes this type of investment and is committed, then that's going to turn into employees. But sometimes the business can be one that is the government feels that it's obvious that this is going to create US employment. The other thing to keep in mind is there could be other factors in the case that make the case very positive or strong case, which could reduce the requirement for a high investment amount. So, for example, the business may already have employees, right? So that is going to, because if investment is a proxy for employees and the business already has employees, then the government might be willing to take a much lower investment amount. Sometimes what you can do is we don't always do this, but sometimes you can include a letter from a CPA. We tend to only do that, and the letter would indicate that the person has spent everything that's required for this particular type of business. We don't tend to do that on the first round. Like we tend to do that if someone has an application, they're denied, and the denial is because of low investment amount. We would encourage them at that point to spend a little bit of money and then more money, and then get a CPA letter, and that's when the CPA letter, I think, becomes more effective. But some consulates that know E-2 visas really well, they're not going to be that persuaded by a CPA letter. I think they realize that it would be easy for people to get one. So they're not going to be that persuaded. The other thing we sometimes include is business articles that indicate that, so even if someone has a consulting business, we might include a number of different business articles from reputable sources that say that this particular type of business can be started with $10,000, but the applicant spent 5 times more than that or something like that. So sometimes that can be useful in terms of an argument. And then the other thing is when people are, if you're buying a business, basically the purchase price is going to be your investment amount for the most part, and that's going to represent the fair market value. I think the one time you do have to look at that more closely is if the parties are related, right? So if something's being sold and it's from a relative to relative or a friend to person, things like that. I think the government could scrutinize that to see if the investment amount is really and the actual investment amount. And what we tend to suggest to people, if the parties are related, is that they get a third-party valuation to legitimize the sale price. So here's some strategies to deal with low investment amount. So some of them we've talked about when we talked about the investment, the amount that's needed. One is to stress other positive factors. So it could be that I know that, for example, when I applied, they really liked my background and experience. I think that helped the case a lot. They liked where I went to school. They liked the fact that I had a business background, and they thought that that was going to be beneficial for ultimately hiring U.S. workers. As I said, if you have employees already, then stress that. And then sometimes types of businesses, like if you're doing a franchise, that can be really helpful. If you're doing a restaurant, like often even though restaurants are tough businesses, then they still are, the government knows that they are employee intensive. So that can be useful. Getting letters of intent or contracts from clients. So the government wants to see that you have prospects, right? So they don't want to just see that you have an idea. They want to see that you have prospects. So letters of intent from various prospective clients can be useful, or even if you already have contracts, that can even be better. You can highlight if the business is already operational, you can highlight ongoing activity and sales. Business plan is going to be key for a startup. So, business plan is should be at least 15 or 20 pages. It's going to be 5 years of financial data, balance sheet, income statement, cash flow statement. It's going to have a personnel plan. Executive summary is going to be key, a couple of pages describing what the business is, who you plan on hiring and when. So that's going to be important. And again, we talked about hiring U.S. employees. That's good. And then sometimes we consider the CPA letter, but again, we tend to go there often when it is a denial and we're reapplying rather than first instance. So some common E-2 expenditures. I'm not going to read these out, but you can, just flip through them. And I think that the one kind of takeaway is that there are some good expenses, so most of the things on this list are good expenses. A few things I'll point out, when it's inventory or even equipment, the regulations say that they can be shipped from another country, and, it doesn't have to be purchased in the US, but you have to be careful with that, especially if the government has more of a buy American, hire American policy. We do encourage encourage people to at least have around 80% of their expenditures in the United States. And you have to be careful with what you include. Like if it's furniture that you're including, it just has to be relevant to the business, right? So it can't be like your own personal furniture, and that can sometimes be an issue with vehicles as well. That sometimes can be an issue. But generally speaking, all of these are good. And then just to keep in mind that for the lease, the money that you include, it can only be money that you have actually paid. It can't be can't just be the 12 months of the lease. It can be like, let's say you paid the first month the security deposit, or let's say even prepaid 6 months, then all that can be included. But you can't just get a lease for a year, even if it's a revocable lease, and say that I'm including the monthly lease payments for 1 year. And here we have some weak expenditures. We talked about the car already. People, food, receipts for Chipotle and McDonald's and things like that. You've seen it all. They came to the United States and they have hotel or the flights. There are some consular websites that explicitly on their website say don't include things like that. It shows that you're reaching and that you have poor business acumen. And I can see why, right? So they're just not business related expenditures. Then the other thing you have to really be careful with is expenses paid to related parties, right? So I had a consult the other day where the person was suggesting paying their own company something, and I explained to them that that for obvious reasons that couldn't be included in the investment amount. So that's something that if the government caught on to, then they would actually think that the individual was trying to misrepresent. So that's something that could be a big problem. So the consulting businesses. So we talked, and I think we talked through some of these already, but let's talk about them a little bit more. So even the law firm, it's a consulting business. We talked. All of these require very low investment, but we want to show an officer that the person is committed. We talked about the articles that you could get, so that's going to be useful. I think we include that in most consulting business files because even I think one of the most challenging things is what to spend money on, and then we give some examples at the bottom of the slide of things that you can bolster your investment amount. And I think one big one is prepaying the rent. Hopefully you need office space, but we definitely recommend that people get office space, even if they just get office space that is inexpensive. I think that even though it's not a requirement for E-2 visas, but I think that it's still very, very beneficial, even if it's just like, a WeWorks fixed desk office space. I think it can be is very beneficial for an E-2 visa. So the webinar is on risky cases. Low investment amount makes a case risky. Another thing that makes a case risky is, kind of lump it all under real estate investment. So someone buys a house and they say they're going to renovate it and flip it, or they're going to renovate it and rent it. And just unfortunately, the government just feels that these are very passive items. So even an individual that is on a student visa or in another type of visa where they're not allowed to work, they could do these things just like investing in the stock market because they're passive in nature. And so unless you have, like when you're doing the kind of buying, flipping, et cetera, we have one client that we did an E-2 for, and that person had over 50 properties. And so unless you have something like that, where it's actually a business, then it's going to be difficult. What we tend to do is when people want to do that, try and reposition it as a home renovation business, because then the inventory is not the houses, which can really, because if you need to spend everything that's required to get the business up and running, and you have to buy multiple houses, that can be problematic. Sometimes we've had success with people who want to buy a plot of land and then it's zoned for 3 properties, and then they are going to build on the 3 properties, and then so we'll include the land, we'll include buying some of the materials for the houses, and we'll position it as a construction company, and that's been successful as well. We've done real estate brokerage firms, so as long as you meet the licensing requirements, that is really what you have to show, because that is a bit difficult, because I think most of them require that you work as an agent for a while, and if you don't have underlying work authorization, it's hard to do that. But As I said, a lot of these we position them as real estate renovation or construction companies, and I think that unless it's house flipping that's on a very grand scale or rentals that's on a very grand scale, then they can often be problematic cases. The other area that can be problematic is cases that deal with equity trading companies. And it's for the same reason, is that often when we see these, the government thinks that it's passive form of investment. And that's particularly the case if you're managing money for yourself, your own money, or you're managing money for your family, right? So day traders or personal investing. And so those don't qualify for an E2, even if you set up an LLC. But if you are managing other people's money, then you have to, of course, get all of the licensing requirements because it's a highly regulated industry. But that can work. We've done a lot of hedge funds, equity trading companies, but in all cases, it's been where the individuals are managing other people's money and they already have significant influx of investment from these third parties, right? So definitely this could work. A big part of the legal fees have to do with the regulatory requirements. There are legal fees related to the regulatory requirements for getting these entities set up. But they definitely are doable, but they can be higher risk cases, especially, as I said, if you're trading your own money or trading on behalf of your family. So, common question that we have is why are some E2 visas denied? And, the one thing to keep in mind is that the approval rates for E2s are quite high. It's got legal, our approval rate is closer to 98, 99%. Past results don't predict future outcome, but, our approval rates are quite high. And even the government posted approval rates for the last couple of years were around the 90% mark. Typically, they're closer to the 81, 82% mark, but that's still really high, right? So most E2 visas do get approved, and I think that the government wants to get them approved. But the ones that don't get approved, sometimes it's low investment amount. I think the one good thing about low investment amount is that you can remedy that. You can spend more money and reapply, and usually that's successful. Sometimes the nature of the business, like I said, if someone has a business that the government feels is passive or is not conducive to hiring U.S. workers, that could be a problem. Sometimes it's just the filing locations. There are, quite frankly, some consulates that are very difficult on E2 visas. And you can't, usually the person has to apply in the country that they're in. There's some exceptions, but unfortunately that, like I said, there are some, I'm not going to name them, but there are some countries where if we say to clients, if they have ability to look at, let's say, have dual passports or something like that, they have ability to apply somewhere else, we strongly suggest it just because they're really, really tough on E2 visas. Usually those countries are tough on other visas as well, but really tough on E2 visas. The other big issue, and this one is very, very hard to overcome, is when the person has a business in their home country and the business is not doing well and or has not hired US workers. So one of our denials in London, that was an IT consulting company, and the person had an IT consulting company in London for 15 years and had never hired workers, and in fact had losses for many years, and the consulate didn't approve that application. And it was probably one of the only applications where the client decided not to reapply, because we did warn the client that this could be an issue, and it ended up being an issue. And but that's another reason why E2 visas, I think that's one of the bigger reasons, and as I said, one that is very difficult to overcome. And it's related to the idea of concerns over whether the business will create US jobs. The other interesting issue, and this just has to do with personalities, unfortunately, is we have had a few people that were denied, and when we talk to them and go over how the interview went, it was very clear that there was like a clash between them and the examiner, and that's just something that you don't want to do. The examiner has all the power in the world. Deference is definitely what you want to do with these meetings, and they can say no, and they don't even have to give you a reason. But in these cases that I'm talking about, they were relatively strong cases. In fact, in both the two that I'm thinking of, they both reapplied and they got the visa, but they just seem to have disagreements with the officer, and sometimes the officers aren't nice, but it doesn't matter. You should show deference if you want the visa. That is, if you don't want the visa, then you can say anything you want to them. But and then the other kind of requirement is the other reason that sometimes things are denied is that just the person doesn't meet the requirements at the time of filing. Sometimes, I mean, this certainly wouldn't be anything that our firm would file, but sometimes people apply on their own and then they're denied, and then they come to us and we're like, well, we had one case where the person applied, and she applied for an E-2 investor visa and she didn't own any of the company. So she wasn't eligible for an E-2 investor visa. And so she came to us and we ended up applying for an E-2 employee visa for her because her parents were the ones who owned the company, but she wasn't aware that that was a requirement. So sometimes that's the reason they're denied, is just that they're not actually eligible at the time of filing. So. Okay, so we talked about these already, the adjudication trends, approval rate. So, I won't go over those again. London is still pretty slow in terms of timelines. They're taking around 75 business days to review applications, and then you can set up interviews shortly after that. But that's a good 4 months. It's a long time. Toronto's back to normal. They're probably setting up interviews about a month or month and a half after applications are filed. So that's great. USCIS versus consulate. The majority of people do apply at a consulate for the reason that if you do a USCIS filing, you are landlocked. You can't leave the US, or if you did leave the US, you would have to go to the consulate and get a visa. So that's why a lot of people typically, especially people who have longer visa validity period, that's what they do. In terms of the most consulates that regularly process E-2 visas will have very specific instructions. You really do have to follow them to the T. Toronto will reject an application if it's 1 page over the 50-page limit that they give. So, some consulates are very, very strict. And they really do lay out exactly what the application should look like, and what should be included. Some consulates will ask for example, if there's a business plan, like for example, Singapore and believe the U.S. consulates in Pakistan ask for the business plans to be certified by CPA, right? So that you do, and again, not doing these things will just result in your application usually being rejected. Not that they bring you to the interview and then deny you. A lot of consulates review the applications before they even let you set up an interview, and then they would reject. So it could be a long delay. Like, let's say you applied in London and then you did something procedurally incorrect and you waited the 75 business days, and then after the 75 business days they came back and said, hey, sorry, you forgot to do this, and then they would just send your application back and they'd say, okay, apply again, and then you have another 75 business days to wait. So it can really drag out the process. Perfect. Okay, so some kind of issues and things that come up in terms of questions. People ask, do you have to hire employees before you apply for an E-2? And you don't. You don't have to. In fact, the majority of startups that we do, probably over 80% of them don't have any employees on the day of application. So it's not required. But what you do want to do is have a really good business plan that shows who you plan on hiring and when you plan on hiring them. If you have a complicated source of funds, the consulates don't tend to focus as much on source of funds. But if you are doing a USCIS filing, it's the opposite. There's an extreme focus on source of funds, not just where the money came from, but also the tracing of the money from origination right through to the business bank account. So those applications are much more complicated. Just because of the source of funds analysis, because USCIS really does treat it as an audit. Loans and gifts are fine for E-2 visas. So you can get a loan from a friend, a family member, a gift from a friend or family member. The only loans that aren't permitted, or the amounts are not included in the investment amount, is if the security for the loan is the business, right? So if you buy a business, for example, and then let's say the seller financing, and seller finance would always be that the seller says, okay, if you don't pay the loan, then I get the business back. And that doesn't work for E-2 visas. We talked at the beginning of the presentation about E-2 visas for two investors, 50-50, so we won't go over that again. If you do have an E-2 visa and then after filing there's a substantive change, you do have to do something. You can't just like continue, let's say you started a business as a restaurant and you decided, hey, I don't want to do that anymore. I want to open up a consulting business, and you close down the restaurant, but you still have the same LLC. Like you can't do that. You have to file an amendment, right? So and you really have to have those conversations with your immigration attorney before you do something, right? Because you'd be technically out of status if the business changed significantly. The other kind of thing that comes up often is when people are buying things from family members, and this can be problematic. We had a case where the person initially was buying, I think, she's buying a gas station, or 50% of a gas station from her sister-in-law or something like that, and her mother had gifted her the money, and we told her this could be a big problem, and she did get it approved, and she was Australian, so it was for 4 years. And then when they went to renew the application, the examiner said this application should never have been approved. This is just money floating around family. And he denied the renewal. And then the applicant had to actually get a new, completely independent E-2 visa in the United States. And this was all during COVID as well. So they went back to Australia, quarantined, et cetera. So, but as I said, we did warn against this, and family business purchases really have to, you really have to make sure that you're presenting information that is makes the transaction look valid. And because, unfortunately, when you go to a consulate, they can deny an application just on a hunch or just something they think, right? They don't even need to give an explanation or a reason. There's no due process when you're outside of the United States. Um, we don't see a significant change in the adjudication of E-2 visas at consulates or even at USCIS for that matter. We didn't see as well a significant change in approval rates on E-2s from 2016 to 2020, although I would say that the last couple of years, the approval rates have been much higher than the average approval rate, but even before 2016, because even before 2016, I think the average approval rate still hovered around the low 80%, like 81, 82%. But it has shot up quite a bit over the last couple of years to closer to 90%. But as I said, we haven't really seen too much of a difference or really any notable difference in adjudications on E2 visas, at least at consulates or USCIS. Perfect. Excellent. Those were all the prepared remarks that I had, and I think Yonki's going to take a look at whether or not there were any questions.
Yeah, thank you for great presentation, Ian, and I hope our attendees, receive the really great information from you. Let's go over with some questions on the Q&A box. First question, I'm a software professional interested to purchase franchise business in food industry. My question on work experience, since I don't have an experience in food industry, will have any negative visa officer standpoint in terms of my visa approval and how I will be up and running business successful in USA.
Yeah, absolutely. Great question. So no, I don't believe that sometimes if someone has particular relevant experience, we will always highlight it and use whatever we can use to their advantage. And then there might be some businesses where, particular expertise is required, right? Like if someone wants to open up a law firm and they're not a lawyer, that's going to be a problem. But in particular, with this question in the example, the person is doing something with a franchise. It's one of the reasons the government loves franchises, because the franchises will train and do different things. So if any business where there's a reasonable expectation that the person could come up to speed, then having prior experience is not going to hurt them. Not having prior experience is not going to hurt them.
Great. Okay, next question. How to convince an officer on intent to depart? I have seen many of them posting in common forums they have issued 214B.
Yeah, so 214B doesn't mean what most people think it means. So 214B doesn't mean that the person doesn't intend to depart. It's a catch-all provision, and when the government denies based on 214B, they don't often explain, but then what they do give is a piece of paper with an explanation that gives a generic explanation that says that sometimes 214B means this, but it doesn't necessarily mean that. It's when an officer decides to just deny a petition, they could deny it on 214B. So, for example, in the example that I mentioned, when the applicant went to to renew, and they said that this is just money floating around the family. The officer denied under 214B. Right. So 214B is not what people often think it is. The E2 visa, the intent to depart the US is normally satisfied in the hundreds of cases that we've done. It has always been satisfied by a note that says, I plan to leave the United States. Now, there could be something in somebody's background that gives the officer more of a question, raises more questions. Like, for example, let's say they have an immigrant petition filed that with a priority date that is coming up that's soon. That could raise a red flags. It could be that someone has been in the United States for a long time already. That could raise a red flag, although I doubt it. Like when I got my E2, I'd been in the United States for 20 years before getting it. Um, so, so I think that 214B is usually not an issue with, because the keep in mind as well as the regulations explicitly say that they're for E2, and this is the only non-immigrant visa category except for dual intent visa categories like H1B or L1, where it explicitly says that you're not required to maintain a home in your foreign country.
Thank you. Next question is, are unsecured personal loans in home country acceptable as a valid source of funds?
Yes.
Okay, great.
Yeah. No other explanation needed. Just the answer to that question is yes. They're accepted. The regulations are explicit that unsecured loans are fine.
Okay, move on. Next question. Let's say my initial visa is approved on food industry in a couple of years. I want to start another line of business, IT consulting. Whether are we allowed legally to open another business?
Well, you're allowed to open another business. I think that if it was an IT consulting business, you would either need to get an amendment if you wanted to do it under the same business. If it was significant, I think if maybe you could maybe argue if it wasn't significant part of that business under the same entity, then you could maybe argue that it's not a material change or a substantive change. But if it was going to be a significant business line, then you'd probably want to get an amendment to allow you to do that. But if you're just opening up the business and let's say someone else is going to be working at it, you're allowed to open up as many businesses as you want. You just aren't allowed to work at them.
Great. Next question, for marketing agencies that require very less expenses, what is SL's experience?
Yeah, so
Scott Rigger's experience.
Oh, Scott,
Okay.
Scotland, yeah, yeah. I think that what I'd do is I'd refer you back to the slide, or you may have come in late, so just kind of watch the video after the slide where I talked about consulting businesses and how much is needed in terms of investment. We do a large number of consulting companies. But what I'd say that what the answer to the question, it was in the kind of presentation. So I just encourage you to go back and listen to that. Like go over when you get the video will come out today, to go and take a look at that section of the presentation.
Okay, thank you. Just one more point to add is that just keep in mind, guys, we are one of the top tier E2 specialized law firm out there you can find. So we are the best. That's why you are here, and we are the best. Okay, next question. I do not have employees for my current business in home country, but if I hire an employee in the US before acceptance, would that work?
Well, I think it could work. I think definitely, because what it is that what I went over in the presentation is that sometimes things that come up, if your business that you are opening up in US is the same business that you have in Hong Kong, and you've had that business for a long time and you've never had employees, then that's a risk factor. So in order to mitigate that risk factor, I think, sure, hiring an employee can mitigate that risk factor. It doesn't eliminate it. I know the way the question was worded, would that work? I'd say the only answer I can give is it would mitigate the risk factor, but not eliminate it.
Okay, next question. Why would it be a problem if two investors, me and my husband, want to share the cost of our startup business, want to apply an E2 visa?
It wouldn't be a problem. You don't need, if you have married, you only need one. You like one of you could decide to be the primary, and the other one would get work authorization anyway.
Okay. Next question. What if I open a holdco LLC? I guess it means a paper company and borrow a gas station. Can I buy another gas station under that hold LLC and then sell the first one until I can be on the same E2 or have to reapply?
Yeah, I don't, I think it's, I think it's possible if it's all gas station business and you have an E2 for one gas station and then you buy another one and then sell the first one. I think that we could make an argument that an amendment is not needed. I think that some people are extremely conservative, right? Like, so sometimes people will set up consults with us and say, like I remember one client, they had an E2 for a pool cleaning business, and then they were transitioning to like kind of cleaning garbage things, garbage bins or something like that. And they asked me if I thought it was material change, and I said I don't think so. I said I would make an argument to do nothing, right? And but then they were really conservative, so they wanted an actual um, opinion letter from USCIS. So we did that for them, and USCIS actually came back shockingly, because I thought if you asked them if anything was a change, I thought they were going to say it was a change, even though I didn't think it was. But they also came back and said that they didn't believe that it was a significant change. So but so it depends on sometimes you're like it depends on because the rules aren't clear cut. The rules just say that if there's a substantive change, you have to file an amendment, right? So then you have to look at what's actually happening and make a determination as to whether or not you feel there's an amendment. But some people are conservative and they don't want the government to later come back and challenge them. So these people like they wanted to file, they paid for filing the advisory opinion because they feel more comfortable with the explicit letter in hand from USCIS saying that this doesn't require an amendment. So sometimes it's a personal choice.
Thank you. Next question is, we are considering an E2. I already work as operation manager already for a USA company in Seattle. If my husband and I do an E2 visa with a new business, can I still work for this USA company? I work remotely in Canada for Seattle company currently.
So if you did an E2 visa and so I think that the way the question is being asked, the answer is no. So if you did an E2 visa, well, sorry. If the person asking the question is the primary, the answer is no. If the person's asking the question is the spouse of someone on an E2, then the answer is yes. Spouse of someone on an E2 can work anywhere. But if the person was a primary and then they wanted to continue working remotely for any company in the United States and then they were the primary on the E2, you can't do that. It doesn't matter that the company's in Canada or in the United States. It doesn't matter. The E2 primary could only work for the E2 company. Now, if the E2 company was providing services to that other company, then certainly that might be a way to do it corp to corp, where the E2 company is providing services if the services are aligned and things like that. So.
Okay, next question is also asked by same person who just asked this question. We also have a business in Canada. Can we still consult for our business in Canada? We work remotely.
Yeah, so I think it's the same answer. If you're in the United States, you can't do work. The fact that it's remote is irrelevant. The government doesn't care whether it's remote. If the government manages working on US soil. So even if if someone's working for a company in Canada remotely and the company in Canada is paying them and they're in the United States, they need a visa to do that.
Okay, next question. Does your company approve doing a review for legit source of funding before you start taking and processing my E2 visa case?
We would do that. We would bill you for it, but we would do it. We'd happy to do it. Yeah.
Sure. Please make a consultation appointment. We'll go through the
Well, I
more
think that
details.
I think you can I think that a lot of the source of funds discussion could occur during the consultation, because I think what would happen is that if there were any red flags, they would come out during a consultation. Now, the devil is in the detail, of course, because it's quite, the source of funds analysis for a USCIS filing is quite complex. But certainly a consultation would be a good next step to iron out whether or not there were any issues.
Okay, next question. I have recently become Canadian citizen. Congratulations. Exploring business opportunity in US. Will be there any issue in visa approval because applicant recently acquired citizenship in Canada? Please
No,
note that I have acquired citizenship as a skilled worker stream.
no. There's no issue as long as your investment is done after you became a citizen. That's the only thing you want to make sure.
Okay. Next question. How can I get my E-2 visa process started with the Scar Legal?
Sure, absolutely. So after this session, we will send around links with a bunch of things. The video, the PowerPoint, also a link to set up a consultation. And then just you could respond to that and say that you want to either set up a consultation, or if you want to get started, we could send you the E-2 visa engagement letter to get started. And yeah, so happy to send us, or if you send us any email through our website or whatever we would get back to you, and we're happy to start whenever you're ready.
Okay, we have only 4 minutes left. We will try to cover all the questions, but just keep in mind that we have to close at a certain point. Next question, how far back do I have to show the source of fund? I have had an investment for 10 years. Do I just show tax document for those funds for the past few years, or do I have to go back to the initial deposit for original deposit?
Yeah, it would go back. You would have to go back, depending on there's sometimes if the investment occurred some time ago, and if they're doing it at consulate, we may use other options. Like we might just use the tax return to show that the investment was made and things like that. But certainly, I'd say it's a good if for the more complex one like that to set up a consultation to go through.
The next question, would it work to show as the legit source of the fund there was a debit from particular company to the investor and then company returned the money to the investor? In his case, would the transaction between company and the investor account showing the money taken and returned to investor account?
Yeah, I'm not sure if I'm not 100% sure I understand what the person's getting at. So, the thing to keep in mind is that the investment has to be made, and it can't be just kind of like you can't just put if what the suggestion is to put money into a business and then the business pay you back, or if the business had paid back, then it wouldn't qualify as investment if the money was paid back. But certainly they could set up a consult to go through that in more detail because I'm not sure I fully understand the question.
Okay. Next question, under holding company LLC, if I mention I'm buying a gas station, can we also open a daycare under the LLC since my wife is a preschool teacher?
Yeah, so I think I answered that question already. I think it's the same person and the same fact pattern. It's
Right.
just a different business, it's a childcare business. So I think it's so what I would encourage, just because of the time, Yonki, if maybe the people, if there's anybody on the list that hasn't asked a question yet, we could just go to them, and then the ones who have many questions, they could just set up a consultation.
Okay, sure. Next question is basically what is your legal fees for E2 process? You
Yep.
can
So
make
just send us an email. Yeah, just send us an
yes,
email and we'll send you
sure.
those.
Okay, thank you for all the valuable questions. If
Perfect.
you have any further questions, please send us email and make appointment for the consultation. We'll go through more details.
Excellent. No,
Ian,
thank you very much.
thank you very
Thank you,
much.
Yonki, and thank you all. It was great speaking. Okay,
Thank
take
you.
care. Bye.